Dokie. Good morning, everyone. Good morning. Thanks for joining today's webinar. My name is David Goldfisher. I chair our firm's landlord-tenant department at Shapes Perlowitz Luftig. I know I've had the honor and privilege of working with a number of you in the past. But thanks for joining. Before I guess we jump into today's topic and session, I'm happy to keep this interactive, and if anyone has a question, you could use the Q&A function or the chat box. Oliver, I believe those are both open to everyone, if I'm not mistaken. So if anyone has any questions you want to interject with a point or question along the way, please feel free to do so, and I'll do my best to address everyone's points as we go along. So starting from the top here, there's of course been a lot of chatter and activity about the eviction moratorium that's been in place since the end of March 2020. And for those of you that either are landlords or represent landlords, this eviction moratorium has really been a sore topic, and it's a very hard conversation to have with both landlords and in some instances, of course, tenants as well. But primarily, of course, for landlords who are facing the brunt of these issues, not being able to evict tenants has really had a double-edged sort of effect. Number one, you're stuck with tenants that might not be fulfilling their obligations of lease, of course. And number two, there's been sort of a sense of empowerment to tenants as well during this time. I field calls, multiple calls, I would say, on a daily basis from landlords struggling with different landlord-tenant issues. And I think that the sense in the industry is that many tenants certainly feel empowered by these new laws, and it's giving wave to lots of pushback as far as leases are concerned. We're seeing people renegotiating leases. We're seeing people just, tenants I'm referring to, just not paying rent. And, it's obvious for anyone that can track the news and see what's going on in this, in the political climate as it relates to rentals, that, the power is really the tenant's court. The pendulum started shifting dramatically back in June of 2019 when the state legislature passed the Housing Stability and Tenant Protection Act. And since then, that balance of power has continued to shift towards the tenants. And, it's something that tenants are fully aware of. And unfortunately, many landlords are now faced with bearing the responsibility and the brunt of these actions. Now, turning right now to the eviction moratorium, before I get into the latest and greatest, there's one point I want to make, and I think there's a certainly amongst landlords that I've been speaking to, I get a sense that there's misunderstanding about how the eviction moratorium works. The eviction moratorium is solely related and strictly focused on evictions, right? It doesn't affect non-payments of rents. So many landlords call me up and say, hey, my tenant hasn't been paying. I know there's an eviction moratorium. I can't evict them. What can I do? There's been nothing since COVID was enacted that allows a tenant to not pay rent or give a tenant a right to not pay rent. There's been nothing, no edict, no law, no legislation, nothing that was issued by the city or the state that allows tenants to forego their rent payments. Now, of course, we all know about the rent program, the state's rent program that's been issued. The numbers are well aware. There's, the rent aid. It was a $2.7 billion rent relief program that was launched this past June. Of that $2.7 billion, from the numbers that are made public, at least only $98 million has been issued and released. So while the state has started some level of assistance as far as rent payments are concerned, there is nothing that allows a tenant to not pay rent under a lease. So you should make that very clear for those of you, again, that are landlords or that have landlord clients. That's crystal clear. If you're dealing with a tenant that's not paying rent, nothing precludes you from commencing a non-payment action now. Granted, housing court is basically at a standstill, and it might take a number of months to collect on this or get a judgment for a non-payment of rent. But at the same time, there really is no reason for a landlord to forfeit their right to commence such actions and forfeit rent. So I just wanted to point that out. Now, getting right to eviction moratoriums, we know about the nationwide moratorium that was issued by the CDC that runs through October. while that program is obviously in effect throughout the entire country, the individual state moratoriums do govern their own jurisdictions. So New York had their own moratorium, which is set to expire in a matter of weeks at the end of the month. And all eyes, or a lot of eyes on the nation, are on New York to see what they're going to do. You know, California recently extended their moratorium. So we are seeing some states take on the burden and responsibility of extending it on their own and foregoing the CDC issue. One important note to make on the CDC moratorium, that the language issued under their prohibition is extremely important. The language used is that the moratorium applies to counties, I'll read it directly here, is substantial and high levels of community transmission. So, you know, it's pretty broad, and, you know, New York's 5 boroughs would certainly fall under that act. But again, we have to monitor and see how many new COVID cases are being reported. This is really what it relates to. It ties directly into the number of COVID cases, the number of issues that are spreading in these counties. So if they comply with that threshold, then they will fall under the CDC's eviction mandate. And again, it's pretty broad, so there is a good chance that it will apply. Now again, so New York's individual moratorium is set to expire at the end of the month. There's been a lot of talk about extending it. I think this is the 3rd or 4th time the moratorium has in fact been extended. You know, people are always asking, what do you think is going to happen? Do you think it's going to get extended? At the end of the day, even let's say it doesn't get extended, right? Come August 31, there's no new extension to the moratorium, and landlords flock to housing court to file their eviction cases. We have to be, you know, we have to be pragmatic here and think about how this is going to look. The housing courts, you know, as I mentioned earlier, are essentially at a standstill as of now. How in the world they're going to handle this, you know, onslaught of eviction cases filed by landlords is going to be, you know, interesting to say the least. You know, I tell people all the time, even during pre-COVID days, pre-COVID world, landlord-tenant court wasn't exactly a model of efficiency, right? You know, ask any landlord during the last couple of years that filed an eviction case pre-COVID, and everyone knows it can take 6 to 8 months, even over a year at times. And again, this is pre-COVID, so who knows how this is going to play out going forward. It's going to be chaotic to say the least. But there is, in fact, you know, there is, in fact, light at the end of the tunnel. There are a lot of landlords that I've seen personally that have been going to Supreme Court, which is, you know, sort of not the venue of choice in the past, but given the lack of other options right now, it's certainly been something that landlords are taking advantage of. We've seen landlords file ejectment actions in Supreme Court, which again is a bit of a novel thing these days, but something that landlords have had success with and have been using. One of the downsides of going to Supreme Court is, you know, it is far more costly than housing court was. However, at the same time, we're having much better results there from the landlord's point of view. You're getting index numbers, and you're getting in front of a judge far quicker than you would have if you would go the housing court route. So there are certain pros there in the Supreme Court aspect. Another important thing I want to touch on is the Senate bill titled S7315 that was passed just a couple of days ago. It was introduced by Councilwoman Alessandra Biaggi, and what this would do would essentially, and now again, this bill is still in the state Senate committee, but if passed, it would extend the COVID protection for both landlords and businesses through the end of October, right, of this year. So while there is no official extension of the moratorium as we sit here today on August 12th, there is a bill in the state Senate committee that is being reviewed and has the potential to pass and extend the moratorium for both landlords and tenants. Now, the interesting thing about the COVID emergency, it's titled the COVID Emergency Eviction and Foreclosure Prevention Act, is that the state Senate, you know, at some point decided that they wanted to essentially throw a bone to landlords, right? So instead of just, you know, having all the protections on tenants, they wanted to allow landlords that fall into certain criteria to avoid foreclosure on their properties. So that's an important note as well. So I guess, one of the silver linings of all this is that the elected officials do have this sense of understanding that landlords are hurting deeply here, and they did take some level of protection and bake into this bill some guidelines for landlords in which they can avoid foreclosure. Now, again, it's not the greatest thing in the world, but it is a positive point in the right direction that they are at least trying to help out the landlords a bit. Another important note I want to make on the rental point of view here is that if you are dealing with, again, if you are a landlord or you're dealing with representing a landlord and you're in a situation where a tenant's not abiding by the terms of the lease, be it not paying rent or they don't want to leave in time, what I tell my clients all the time is that the nuclear option that you want to avoid at all costs is when you're dealing with a tenant that's, number one, not vacating in a timely fashion, meaning when their lease expires or when you terminate their lease. And number two, they're not paying rent. It is the absolute worst option. You have to be very careful to avoid that at all costs. And as crazy as this sounds, I've actually, told some of my landlord clients that if you are dealing with a holdover situation, it's getting real bad, go ahead and tell the tenant, make a deal with them. Say you'll waive back rent, or worst case, you'll even have to potentially pay them off to just get out. You don't want to deal with a situation where a tenant is just staying in place and not vacating when their lease expires and not paying rent, of course. So that's also something you really want to keep in mind. And of course, just be mindful about the self-help options that landlords on the residential side certainly cannot rely on. I get questions from landlords all the time saying, can I lock out the tenant? Can I go in there and just move out all his belongings? Absolutely not. If you're a landlord, one of the worst things you can do is go into a tenant space without their permission and do anything that's moving their items, changing the locks. That's a major no-no. You legitimately get thrown in jail for that. So it's certainly something very important you want to keep in mind. Another very important thing to keep in mind as it relates to the eviction moratorium is that the eviction moratorium does not preclude a landlord from terminating a lease. Now, this applies to leases that are upcoming and have set expiration dates. It also applies to tenants that are on a month-to-month basis. An important note to keep in mind is that if you have a tenant whose lease expired, say, July 31, and you let them continue to stay there, they're paying rent, that tenant by default becomes a month-to-month tenant. Now, all the terms of the initial lease still apply. However, going forward, that tenant has what's called a month-to-month status. And in June of 2019, when the state legislature passed the Housing Stability and Tenant Protection Act, they enacted certain notice requirements for landlords to follow when terminating leases. And again, this applies to leases that both have a clearly defined expiration date. It also applies to tenants that are on a month-to-month basis. So for example, and just a quick note, this notice requirement is based on how long the tenant has remained in the unit. So if the tenant has been there for 1 year or less, it's 30 days. If they've been there between 1 and 2 years, it's 60 days. And for 2 years or more, it's 90 days. So it's very, very important as a landlord to keep these notice requirements in mind. If you're dealing with a month-to-month tenant and you want to terminate their lease, you must abide by these notice requirements. And this actually occurs quite frequently on the transactional side. Our firm, we have a large transactional department here, and we represent buyers and sellers all the time. And it's very tricky as a seller when you are dealing with a property that has tenants in place. And this is more common in, I would say, 2 to 3 family townhouses. The landlord might be renting out a ground floor or a parlor floor or whatever it is, second or third floor, and they want to sell the building vacant, or they're representing that they will sell the building vacant while there is currently a tenant. And as a buyer, the buyers are always entering the contract under this assumption that at closing, the premises will, of course, be delivered vacant. However, the landlord doesn't always abide or is not always aware of certain notice requirements, right? So you don't want to be in the situation where you're involved in a transaction, there's tenants in place, and the current owner, the current landlord of the property is not abiding by the notice requirements and then getting pushback from the tenant in order to vacate in a timely fashion. These are again, issue that we're seeing crop up, unfortunately, all the time. Just, on a sort of party note here, the one thing to keep in mind is that if the state does not go ahead and extend the current moratorium, I would fully expect the housing board here to certainly continue to enforce the CDC guidelines. So if you are representing a landlord, just because that, the state moratorium expires at the end of the month, I would certainly not rely on this going forward and say, hey, come August 31 or September 1, we're going to run to court and file our evictions, get these tenants out. Unfortunately, you want to take the long view here and, understand that this is far from over. It's certainly something that's on the minds of all the, Supreme Court, all the elected officials throughout the entire country as it relates to the eviction moratorium. There's a lot of pressure, quite frankly, from tenants on these officials to make sure that this gets extended, and in all likelihood, it certainly will, be it on the state level or the nationwide level, which has already been enacted. So these are very important points to keep in mind, and going forward, just make sure you're on with as much knowledge as possible. It's a very delicate situation here, so you want to be as careful as you can. If anyone has any questions, feel free to chime in. I know Oliver, after the fact here, will circulate my contact info for anyone that wants to reach out. Please don't hesitate. I'm readily available and happy to be a resource for you guys. If you have any questions, or you want to pick my brain about any landlord-tenant related matters. Oliver, we're going to circulate contact info, correct?
Yeah, I'm going to send an email after this with also like the link to this replay, so everybody can watch it again, or if they have any questions, they can reach out to you. But yeah, all your contact information will be there as well.
Awesome. All right. All right. Any questions? Anyone want to discuss anything? All right then. Well, thanks. Oh, wait, we have Jeff. You have a question? Oliver, are you able to unmute?
Yeah, I just unmuted him.
Okay, so my question is, can a landlord charge, let's say, 3 months rent at a time, or can a landlord only charge month-to-month rent?
You're talking about during
your lease. Like, for example, let's just say August, September, October, they take a payment in October or whatever, and then another 3 months down the road they take another payment. Is that?
Yeah, unfortunately, that would not be allowed, as it would qualify as upfront rent, which we all know is no longer allowed by the state legislature. Now, again, if a tenant is in arrears, however, meaning let's say they fell behind a few months, they want to make a lump sum payment, that is certainly allowed, of course. But to pay months in advance, unfortunately, a landlord cannot accept that.
Gotcha. Thank you.
Yep.
I think there's a couple questions in the chat now.
Yeah, hey, I see a question from Nicolina. The ERAP program, yeah, the tenant, the Rental Protection Act, it hasn't been a glowing success, as I'm sure everyone knows. I think I cited the numbers before. I think I had them up here on my notes. What is it? $1.7 billion that was set aside for the rent program, and I think only where's the numbers here? 98 million out of 2.7 billion was actually distributed. So I think that says enough about the program's success. Unfortunately, the rollout was certainly not handled well. We hear stories about those that applied and either never heard back or never got the money. It was websites crashing. It was a bit of a mess. The hope is now that as things progress, as a little momentum comes in, we have some more positive production here. But it's certainly, by all measures, by all indicators, has not been a glowing success. Here's a question from Brian. Can you restate the notice time that you mentioned based on the amount of time they have been in place? Yes, correct. Yes, it was 30, 60, 90. And the qualifiers are as follows. If you're a tenant that's been in the unit for 1 year or less, it's 30 days. Between 1 and 2 years, it's 60 days. And 2 years plus is 90 days. So important to keep those notice requirements in mind. And again, it's based on how long, even if you're not a tenant listed on the lease, these notice requirements apply. So if you were just, if you were roommates and your roommate was listed on the lease, you weren't even listed, it doesn't matter. It's as long as you have physically been living in the unit. Here we have a question from Diane Solarte. Can condos and co-ops now charge additional security? That's a great question. So we all know, as I was just touching upon, the restrictions against paying upfront rent and also the restrictions against paying additional deposit. Deposits we all know are limited to 1 month in rent. The state legislator inadvertently in 2019 accidentally looped in condos and co-ops to this restriction. Now, there was recent legislation that amended the Housing Stability Tenant Protection Act for condos. So condos can certainly charge more, and we've been seeing that occur. Co-ops have yet to be carved out of this exception, but there is state legislation that's in the works right now that is going to qualify for co-ops. And quite frankly, as I'm sure you're aware as well, I've been seeing most co-ops throughout the building continue to charge deposits far in excess of 1 month rent, since their understanding is that they're exempt from it. But there will be legislation, hopefully within the next few months, that will exempt co-ops. Condos right now are absolutely exempt. Here's a question from Anthony. Any truth to rumors of a $100,000 fine for landlords who seek to evict based on non-payment of rent? No, that's not true. One important point that I actually do want to touch on, Anthony, as it relates to the moratorium, is that the moratorium protects you, and I'm talking about the CDC moratorium. The moratorium protects you, assuming you have been, what's called basically an upstanding tenant. You haven't been harassing other people. You haven't been a nuisance in the building, and you also have to demonstrate some level of an attempt to actually pay your rent. You can't just sit there and say, hey, there's a moratorium, I'm not paying rent. I still have an income, I'm still getting paid by my job, and I'm not paying rent. That won't fly. I mean, if you get in front of a court and you can't demonstrate that, again, it's a pretty low threshold to cross, but it's a threshold nonetheless. You can't show that you actually made some level of attempt to pay your rent. That won't hold any water, and you will actually, in all likelihood, be faced with an eviction warrant. So that's certainly something to keep in mind. Here's a question from Linda. What are the notice requirements for a shorter term lease, less than a year? Good question. Less than a year, you still have the 30-day notice requirement. That's the 30-day notice requirement is the minimum amount required for tenants.
I think there's one more, David, from Linda in the chat.
Yeah, no, I just addressed that. That was, yeah.
Oh, I apologize.
All good.
That's it then.
Any last calls?
Oh, maybe one from Brian that just came in.
Yeah. Can you talk about going to Supreme Court for evictions a little more and how it would cost? Listen, the cost obviously varies. It varies by attorney. It varies on how complex the case is. I figure you're just to start in Supreme Court would probably cost between $5,000 and $7,500. But again, the benefits are that you'll get an index number. You'll get the case rolling far quicker than you would in housing court. Number one. Number two, there is this sort of loophole called an ejectment action, which functions essentially the same way as an eviction. But again, it's just not covered under the quote unquote eviction moratorium. So that's one of the benefits of Supreme Court. And again, even for non-payment of rent, I'm seeing landlords go to Supreme Court, and just because it's quicker to get a judgment, it's quicker to get an action there, and just far more efficient, albeit at a higher cost. The timeline, I mean, you start a case in Supreme Court, I would imagine most of my experience here, I've seen you'll get a case within a month to 6 weeks, which is pretty solid. So also listen, it compels, it's no joking matter. It brings a tenant to court. They have to answer. They have to file a motion. They have to hire an attorney. It's pretty legitimate. You can't just shrug away your duties here and think that Supreme Court's not going to issue a lien or a judgment against you if you don't respond. It's a pretty serious matter.
Okay, I think that might be it. If there's any other questions. Oh, one just came in.
Oh, one just popped in. Any difference in getting a warrant of eviction from Supreme Court and would the sheriff's require any specific language on the order? Yes, so from Supreme Court, you're not going to get necessarily an eviction. You're going to get an ejectment. Ultimately, once the judge signs off on it, the sheriff will have to act, right? If the sheriff can't just come, if they have an eviction warrant in hand, they can't just disregard it, right? It's all about the judge signing off on it. And if the case warrants it, if it's on the merits, and the tenant wasn't complying with the necessary threshold that I discussed earlier about showing they made some level of an attempt to make payments, then there could in fact be an eviction issued here. Yeah, absolutely. All right. Well, if no one else has any questions, I guess we'll wrap it up. Thank you all very much for joining. I hope you found this insightful and useful. And again, please don't hesitate to reach out if you have any questions, comments. You want to pick my brain about something? I'm here. I'm available. Oliver will be in touch with contact info. And have a great rest of your day, everyone.